Bruce, let's talk about some cases that stand out in your mind as examples of judicial activism.
Well, the classic example, of course, is Roe versus Wade. That gave us a national constitutional right, quote unquote, to abortion. You know, judges took it upon themselves to essentially legislate from the bench because there was no right in the Constitution. They looked in the emanations and penumbras, whatever those are, of the other rights in the Constitution and decided to impose a national policy on the country and then kind of work their way through the Constitution to find a way to do it. That is the very definition of judicial activism.
So how do we keep activists off the courts?
Well, you know, most judges are appointed by elected officials that you and I elect. Some of them run in states where it is an election and there is kind of a give and take of I stand for this or what have you. But one major political party stands for judges who feel restricted by the Constitution and abide by the text of it, as well as the original understanding of the founders who basically wrote the Constitution. Another of the major parties believes that judges should be governed by what's called the living Constitution. And that is nothing other than saying that we feel that the Constitution is too old, it needs to be updated, and the person to update that Constitution is the judge, who is enlightened and one of the elites of our country, and therefore we should trust them to modernize the Constitution for us. But really, in essence, what that means is we're leaving our laws in the hands of people that, you know, we have no idea what they believe or whether they believe truly on what the country stands for. And so that's how we keep these guys off the bench, is simply by voting for people who will appoint the right judges with the right judicial philosophy for our nation's courts.